Also, there's something called bona fide occupational qualifications, and that's an exception to when you can state a preference. Um, an example of that would be, for instance, if you were in a maximum security penitentiary for men, you can require employees to be men. There is no allowed exception for customer preference. A good example is the famous Domino's case, which said that we hired white drivers for white neighborhoods and black drivers for black neighborhoods because that's what our clients or customers wanted. You can't do that. Other known BFOQ exceptions would be if you had some sort of themed restaurant. For instance, if you had a Chinese restaurant, some courts have allowed people to hire somebody that is Asian to fit the motif. Many people, when they advertise, use the expression equal opportunity employer. That term actually means something. It means that you are a federal contractor and you have some affirmative action requirements. So make sure you understand if you're using that expression, why you're using it, and if it actually applies to you. Also, some people worry about ADA or the Americans with Disability Act concerns. The ADA doesn't require employers to actively recruit individuals with disabilities. However, an employee may not, however, engage in recruitment activities that exclude candidates with disabilities and should make information about job openings available to people with disabilities so you don't get an allegation of some sort of disparate impact. Now let's turn to employment applications. Truth be told, just about every employment application I get from a client when they ask me to review it stinks. And many times I just want to tear it up and start anew. I'm going to address some of the different problems I've found with employment applications and touch upon them. I won't be able to go deep into all of them, but I'll try to highlight some of the important things. First is format. An employer should consider whether the question is one that's prohibited by law, such as one that discriminates against or adversely impacts a protected group. Employers should also determine whether information request is necessary for the hiring decision. An employer should keep in mind that it may be required to justify the inquiry at some time in the future. If an employer must ask questions that might be viewed as discriminatory, such as medical questions, make sure you obtain this data after a conditional offer of employment is made or after the person's been hired. All medical information, for instance, including drug testing information, should always be kept in a separate file from the employee's personnel information. So the format of the application is very important. I also think it's important to have a non-discrimination statement where you state that you're not going to exclude people based upon protected categories. Also, again, you may have to use the information that you're an equal employment opportunity employer if you fall under the affirmative action requirements. As far as disabled candidates, when providing a candidate with an employment application, an employer should ensure that the applicants with disabilities have an opportunity to fill out the application. This may involve making a reasonable accommodation, such as helping an individual with a visual impairment complete the application form. As far as active status, to reduce the likelihood of legal claims when a position is filled long after an application was received from an unsuccessful applicant, it may be beneficial for the application to state that it's only considered active for a specified period of time, such as 30 days. I've had a lot of people or a lot of employers receive applications, and every time this person's passed over for a job, they may claim that that's a new job they were passed over and a new possible claim. So I would state on your application how long it's actually active for, and specifically say if you're not hired for a certain job, you have to reapply for future positions. Also, something about their status may change, or they may have some sort of criminal history or something like that. Information authorization and indemnification. You also, on the application, are going to want someone somewhere on there that says that you authorize the company to do a background check on you. And there's specific language you'd want to use to comply with the Fair Credit Reporting Act. You'd also want on your application to say that any false or misleading or error on the application, basically showing dishonesty, could be a job disqualifier, because we want to one day say, hey, Jane lied on her application, so therefore she's being terminated. We don't want Jane to say, oh, well, they never mentioned or they didn't have any policy regarding that. The reason that's important is because it's what's called after acquired evidence. If, gosh forbid, you have to defend a case, we oftentimes want to say that the employee never would have been hired or their employment would have been cut short if we had known about something in the beginning. You also want an application, I'm going to want to have at-will language, and basically saying you can get rid of somebody for any reason, no reason, bad reason, as long as it's not an unlawful discriminatory reason. This is going to sound cold and callous, but here's the truth. The truth of the matter is that when somebody wants to come to work for you, they'll sign anything. So I mean this somewhat tongue-in-cheek, but the best time to stick it to somebody is when they're filling out the application. Because if there's really something you want to enforce, have them sign it at the application period. I see a lot of people that show me 100-page or 80-page employee handbooks with all of the terrible things the company can do to you for whatever reason, all the rules and procedures. I think that's probably a mistake. Unions sometimes get a hold of these things and bang it over the head of the employer if they're trying to organize. Also, handbooks are supposed to make people feel good about working for a company. So a lot of the policies that people have in their employee handbooks, I prefer to have in the application instead because, again, they're more likely to sign that, and you know full well they can't deny that they filled out their application. A lot of people have arbitration provisions in their application. I will be candid, I do not like arbitration provisions, but I know some of my clients do and strongly disagree with me. Congress is actually looking at this right now, whether or not arbitration employment law claims should be allowed. They're even considering putting a new law out there that says arbitration should be unlawful. If you want to do an arbitration provision, that's fine. Just understand the odds are that you're probably going to increase your costs, and the chances of you ever fully winning a case, which you very well can do in federal court or state court, odds are an arbitrator is going to split the baby, so it may end up costing you a lot more money. What I recommend in an application instead of arbitration are what are called jury trial and class action waivers. At least in Florida and Georgia, these have been found to be enforceable. One of the main reasons plaintiffs' attorneys love taking employment law cases is another chance to get in front of a jury. If you take that opportunity away from them, it would be a huge disincentive to them suing you. Also, statistics show that a bench trial or a trial before a judge normally lasts about 1.5 days, whereas a jury trial on average is going to last 4 days. Now, class action waiver is something a little different. What that says is the employee will never participate in a class action against you. Here in Florida, we are ground zero for wage and hour cases, mostly filed by the Morgan & Morgan law firm. And they invariably bring these as class or what are called collective actions. We want to be very careful to try to exclude those, and I highly recommend employers use them because they're a great shield against multi-party lawsuits. And again, they have been found to be lawful in both Florida and Georgia. Now, the Obama administration is again looking at this as well as Congress, and right now we have a pro-employee Congress. They may have some laws out there to try to limit this, but I think while you have an opportunity to use it, you should. Some other problems that occur on applications is, for instance, asking for a maiden name. That can, determine whether or not somebody's married. Under many state laws, marital status discrimination is prohibited, so you got to make sure that that's very important. The one reason you may want to ask maiden names is to do a background check on somebody because they could have been arrested under a previous name. So I don't have any problems asking somebody's maiden name or nickname or gang name, but just keep in mind that that is a possibility. It could be a cause of action if they're going to claim they weren't hired because of marital status. One of the questions I see that can be problematic on an application is asking the relationship to the person to notify an emergency. Again, there are sexual orientation provisions in certain jurisdictions, also marital status. So I don't think you need to ask your relationship to the person, simply who you want, the employee wants or the applicant wants you to contact in case of emergency.